Nikki Jovicic from Lookupstrata and also the Managing Director of Tower Body Corporate. I'm speaking today with Todd Garsden, partner at Mahoneys and Gerard Brody, an independent consultant working in the consumer advocacy, governance and public policy space. Welcome to this important discussion on unfair contracts and their impact on lot owners within the strata industry. This issue has national relevance and we'll be exploring the complexities surrounding consumer protection and whether a body corporate or owners corporation qualifies as a consumer under the Australian consumer law. Recent concerns about unethical practices in the strata industry highlight the need for clarity and potential reform in this area. Gerard will explain the legalities of unfair contract terms and how the legislative framework applies or doesn't apply to owners' corporations. He'll also explore solutions implemented in specific jurisdictions like Victoria and discuss potential reforms, both for contract terms and broader consumer protection measures. And Todd will shed light on how these issues might unfold in everyday strata management scenarios or body corporates. He'll offer valuable insights for committee members who may encounter unfair contracts or be pressured to enter into them. We'll conclude by addressing a crucial question. Is there a measure of hope for lot owners navigating potentially unfair contracts within the strata system? Gerard and Todd, thanks so much for joining me today. Can you elaborate on the specific types of unfair contract terms prohibited by the ACL, please?
Yeah, so the Australian consumer law has prohibited unfair contract terms since it really came into effect in about 2010. And what it does is that it says that terms are unfair. There's sort of three criteria. The first is if they cause a significant imbalance in the parties' rights and obligations. And secondly, the important one, I think, is that the term is not reasonably necessary to protect the legitimate interests of the party advantaged by the term. So that's the bigger party, obviously. And the third is the term would cause detriment should it be relied upon by the weaker party. It's not sort of cut and dry exactly whether a term is unfair, so you have to assess it against those criteria. But the types of things that are unfair is, a term that would unfairly penalise one party or put an additional cost or fee that's unavoidable in circumstances when there isn't a legitimate service being provided, or preventing some action. So terms of contracts which might prevent you taking action against the contractor, for example. Those sort of things can amount to unfair contract terms.
And why is there a current lack of protection for owners, corporations or body corporates under the ACL, even though they may enter into contracts for essential services?
Yeah, so the Australian consumer law, it's meant to apply economy-wide to all sorts of transactions. But in terms of the unfair contract term rules, they apply either to consumer contracts or small business contracts. And for a consumer contract, the definition is it's got to be to an individual as a consumer. Now, an owner's corporation is not an individual, so it won't apply. And in terms of a small business contract, that only applies if the entity is participating in a business. Again, an owner's corporation isn't really running a business, so it won't necessarily apply. And so I think that's really what leaves owners' corporations in a tricky place, that the contracts that they enter into are not necessarily going to be contracts that are covered by the prohibition on unfair contract terms.
Building on the Victorian example, are you aware of what's happening in other jurisdictions around Australia? Who is addressing this issue?
Well, the issue has been partly addressed in Victoria. So there were amendments made to owners corporation legislation in 2019 that does enable an owners corporation to claim that a term of a management contract is unfair. That effectively allows an owners corporation to make application to VCAT, the Victorian Civil and Administrative Tribunal. And that provision actually draws on the definition of an unfair contract term under the Australian consumer law that I mentioned before. So that's a positive development, I think, and it gives one avenue for owners corporations in Victoria if they're concerned that their management contract is unfair or has unfair terms. I don't think it's a full solution because owners corporations, they'll enter into a contract with a OC manager, but they also enter other sorts of contracts as well directly. And so that may not be covered by that provision. And of course, that applies in Victoria. I'm not aware of similar rules in other states and territories. There may well be, I'm just not aware of it.
And when you say management contracts, that's specifically with owners corporation management. It doesn't go to building management contracts or any other type of contract.
No, that's right. It's specific with owners corporation management.
Looking towards the future, what reforms do you see as essential, not just for unfair contract terms, but also for broader unfair trading practices under the Australian consumer law?
I definitely think this is a gap that should be addressed by amendments so that the unfair contract term laws that apply at the moment apply to owners corporation and contracts that owners corporations enter. And that could be changed by, I guess, just changing the definition of consumer contract under the law to include contracts entered into by owners corporations. I mean, more broadly, you're right. Consumer groups around the country have been advocating for reform to the Australian consumer law around an unfair trading prohibition. This would really go to not just terms of a contract, but other sorts of practices or tactics used by businesses that may be unfair. So, by unfair, anything that really I guess distorts the free choices of the consumer to make choices that are in their own economic interests, and there's no sort of legitimate basis for the business imposing something on a consumer. So that could include some things around, the way information is provided. Often online, we're seeing today, tricky subscription traps or, nudges online that seek to manipulate your choice. Or it could be, the way in which there might be barriers to customer service that are put in place that makes it difficult to get help when you need it after you've entered into a service arrangement. So we are hopeful that that law will progress. The Treasury did consult on that idea late last year, and I understand that, there's going to be further work in perhaps extending the consumer law to prohibit unfair trade practices that I'm hopeful will apply broadly, so it would include owners corporations, not just consumer matters.
Excellent. Well, that sounds fairly positive.
There's an interesting segue, perhaps following on from what Gerard was just talking about. Obviously, my experience and knowledge is more Queensland-centric, but in terms of other avenues of protection, something that's quite recently changed in our legislation here is the Code of Conduct for service contractors, and that now specifically stops body corporate manager or a caretaker from unfairly influencing an outcome of the body corporate's decision. So that kind of brings in precisely what you were just talking about what other sort of protections are people looking at to give the choice back to the owners rather than sort of the control of contractors.
That was part of the strata legislation changes that just came in on the 1st of May. Is that correct?
That's right. Yep.
Can you walk us through some practical scenarios where unfair contract terms might arise in the context of a body corporate?
Yeah, and I think quite interestingly, it's anytime there's a service contractor that's going to be engaged, making a list of who that could be. Bodies corporate deal with dozens of contractors, electricians, repairmen, body corporate managers, lawyers, accountants, auditors. These are all people that deal with bodies corporate every day. And in fact, an auditor is someone they're almost obliged to deal with. When those contractors fit the definition of that small business contract, less than 100 people or the turnover limits, they're going to be brought into this Australian consumer law issues. I almost feel it's not necessarily the intention of that legislation. It's similar to when they made the work health and safety changes, and then they went along and then people realised later on, bodies corporate are caught by this too. I think it's a similar sort of outcome here where this probably wasn't done with bodies corporate in mind. But all of a sudden, people are starting to realise, and this isn't necessarily a new thing, that bodies corporate are potentially given the protection from some of these ACL issues. And given we're only talking about it now, I think this is going to be news to a lot of people.
Definitely, I'd agree with that. So what steps can a committee take if they suspect a contract might be unfair or are pressured into accepting one?
Yeah, and I think something to remember is that bodies corporate should have, and almost always do, actually have the choice. A lot of the time it might be portrayed that they don't. So the decision to engage someone is that of the body corporate and not someone else. So whether that's the committee or whether it's the owners at a general meeting, I think what should be remembered is it's those decision makers that get to make the choice, and it shouldn't be up to someone else. So if the committee's not sure, you can refer it to the owners, and then the general meeting, all the owners can participate in that decision making process. Any contract can be negotiated, and something that I guess is not often done is that part of negotiation is sometimes no and finding someone else. There's always contractors available to do a job for a body corporate. It might not necessarily be as easy to find another builder or something like that, but there's suites of contractors that would be wanting to work with bodies corporate for their job. So a lot of the time, something that doesn't happen that we're starting to recommend to bodies corporate is to go to tender, whether that's a big building contract or a painting contract or a new management structure. When there's the ability to do it, then you should be going to tender and making people fight for your business. It's not as complicated or difficult as it seems, and there's some good service providers out there that can run a really good and comprehensive tender, whether it's electricity, remediation works, anything like that. So negotiating the contract, going out to tender are two sort of practical hands-on ones, but also getting advice on a contract from someone who's familiar with those types of contracts, like a lawyer or something like that, can also help, because they can tell you what you should be worried about and what you shouldn't be worried about.
Given the current legal landscape, what proactive measures can committees implement to safeguard themselves and their owners for potential unfair contracts?
Yeah, I think it's a combination of some of the things we just mentioned. It's having a list of, I guess, service providers that the committee can trust and is willing to work with, and allowing a competitive sort of quotation process. So it doesn't have to be a formal tender with a specification and a deadline, but just sometimes getting 2 or 3 quotes on the same issue rather than just getting the first quote or the cheapest quote is quite important. Something that I advise quite regularly is that when you're comparing 2 different things, you've got to compare like for like, or at least understand the difference between an apple and an orange. So if you've got 2 quotes to carry out some building works, a lot of the time what will go into the motion or what people will look at is ultimately the contract figure. So you might have the same scope of works, one's for 100,000 and one's for 200,000. You'd be pretty confident people are going to pick 100,000. But something that no one really looks at is, well, what are the terms of that $100,000 contract? What are the terms of that $200,000 contract? You might actually look at the detail, and the $200,000 contract might be more favourable or more balanced to the body corporate, and in some times might actually work out more efficiently or cheaper if the 100,000 scopes out half the things you're trying to achieve. So putting price to one side, it's also about the entire scope of what you're actually contracting with, because what I suspect Gerard to be familiar with is a lot of the unfair terms in a contract aren't the big commercial terms at the front. Talk about timing and cost and parties. It's the stuff hidden in the back about what happens when something goes wrong. And they're the things that people don't even look at. So yeah, I think doing that and looking at tender processes and getting consultants the right advice for the right circumstance.
To agree with Todd, I think he's entirely right that the most, I guess, common forms of unfair contract terms are those ones that people don't expect. They do come later in the process, a hidden condition about cancellation or something like that. The main terms for contract, the price, the service, people look at that up front, so they're aware. It's those hidden ones that, that's why the law really exists. It's there to recognize that, you can be competition around those upfront terms, but not really around the hidden terms if the consumer is not fully aware of them, because they're often hidden in fine print. And so in this respect, I think, owners corporations are in a very similar position to consumers. So there's really no reason that they should be excluded from the general law.
Is there a measure of hope for lot owners navigating potentially unfair contracts within the strata system?
The reality is that owners, corporations and their lot owners are in a very precarious position. Often they're buying into arrangements when many of these services have been set up by developers or initial members of that owner's corporation, and they may not have much choice anymore, and contracts are assigned and things are imposed on them. So I think that's why we do need to look at law reform in this area to sort of rebalance the rights and obligations, to give a bit more power back to owners, corporations and lot owners.
If it's going to shift, it's never going to shift away from consumer protection. they're never going to take away rights from a consumer. So it's always going to be moving in the right direction. It's probably just a matter of timing. But I think that's quite a future-looking view. But if you look at what exists now, there are still lots of mechanisms for protection that are out there. And I think the biggest thing is that people don't know they exist, or people don't know when they can be using it to their advantage. So I think it's really a knowledge and education thing for now, and it may not necessarily be such a desperate position. So I think to answer the question, there's definitely hope, but I don't think that is tied to sweeping reforms, although absolutely that would shed light on the situation and definitely help, which is what sort of Gerard's getting at.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.